All right, stop what you're doing right now, because what I'm about to tell you could completely reshape the Second Amendment as we know it. The Supreme Court just made a move that has gun rights advocates celebrating in the streets and gun control supporters absolutely terrified. We're talking about a case that could potentially end assault weapon bans across the entire United States. Every single one of them gone. And whether you own a gun, hate guns, or have never even thought about this issue, this ruling is going to affect you. So buckle up, because we're diving deep into one of the most explosive legal battles of our generation. Let me paint the picture for you. The Supreme Court recently decided to take up a case that challenges state-level assault weapon bans. Now, I know what some of you are thinking. Wait, what's an assault weapon ban? Great question. Let's break this down piece by piece, because understanding this is crucial. An assault weapon ban is essentially a law that restricts or completely prohibits civilians from owning certain types of semi-automatic firearms. These are guns that fire one bullet per trigger pull and automatically load the next round. We're talking about firearms like the AR-15, AK-47 variants, and similar rifles that have features like detachable magazines, pistol grips, or certain barrel characteristics. Now, here's where it gets interesting. These bans exist in several states across America: California, New York, Connecticut, Massachusetts, Maryland, New Jersey, Hawaii. They all have some form of assault weapon ban on the books. But here's the kicker. Gun rights groups have been challenging these bans for years, arguing they violate the Second Amendment. And now, for the first time in recent history, the Supreme Court is actually going to hear one of these challenges. This is huge. This is like the legal equivalent of a Category 5 hurricane making landfall. The case in question comes from one of these states. Let's say it's challenging a state law that bans the sale, manufacture, and possession of assault weapons. The plaintiffs, which include gun owners and Second Amendment advocacy groups, are arguing that these weapons are in common use for lawful purposes like self-defense, hunting, and sport shooting. They're saying that under the Constitution, you can't ban firearms that are commonly owned by law-abiding citizens. And get this, there are an estimated 20 to 30 million AR-15 style rifles alone in civilian hands in the United States. That's more than the total number of Ford F-150 trucks on American roads. Think about that for a second. The lower courts had previously upheld the assault weapon ban, saying that states have the right to regulate dangerous weapons in the interest of public safety. But the Supreme Court just said, hold on, we need to take a closer look at this. And that decision, that simple act of agreeing to hear the case, sent shockwaves through the legal and political world. Now, let's talk about why this is such a monumental moment. To understand that, we need to rewind to 2022. That's when the Supreme Court dropped a bombshell decision in a case called New York State Rifle and Pistol Association versus Bruin. This case completely changed the game for Second Amendment law. Before Bruin, courts used something called interest balancing to decide gun cases. Basically, they'd weigh the government's interest in public safety against an individual's right to bear arms. Sounds reasonable, right? Well, the Supreme Court said, nope, not anymore. In the Bruin decision, the court established a new test. Any gun regulation must be consistent with the nation's historical tradition of firearm regulation. In other words, if you want to restrict guns, you need to show that similar restrictions existed when the Second Amendment was written or during the relevant historical period. This is massive. This is like changing the rules of the game in the fourth quarter. Under this new standard, the government can't just say, we think this ban makes people safer. They have to prove that the founding fathers or early Americans would have supported similar restrictions. And here's the problem for assault weapon bans. Semi-automatic rifles with detachable magazines didn't exist in 1791. The musket was cutting-edge technology back then. So now you've got this legal framework where assault weapon bans are being challenged under a historical test that some legal scholars say is nearly impossible for modern regulations to pass. It's like asking someone to prove that the founders would have supported internet privacy laws when they'd never even conceived of the internet. And here's where it gets even more interesting. Since the Bruin decision, lower courts across the country have been split on how to apply this new test. Some courts have struck down gun regulations left and right. Others have found creative ways to uphold them by pointing to historical analogs, similar laws from the past that they argue justify modern restrictions. The legal landscape has become an absolute mess. And when lower courts are split like this, that's exactly when the Supreme Court steps in to clarify the law. Think about what's at stake here. We're not just talking about one state's law. We're talking about a precedent that could affect assault weapon bans in multiple states, potentially impacting tens of millions of gun owners and hundreds of millions of Americans who live in those states. This ruling could determine whether states have any power to ban specific categories of firearms or whether the Second Amendment protects access to virtually any weapon in common use. Let's dive into the actual arguments, because both sides have compelling points, and this isn't as black and white as social media wants you to believe. The challengers, the people fighting against the assault weapon bans, have several powerful arguments. First, they point to those numbers I mentioned earlier: 20 to 30 million AR-15 style rifles in civilian hands. They argue that when a firearm is this common, it can't possibly be considered unusual or dangerous enough to ban. The Supreme Court has previously said that the Second Amendment protects weapons in common use for lawful purposes. With numbers like that, how can you argue these weapons aren't in common use? Second, they emphasize that these are semi-automatic weapons, not fully automatic machine guns. One trigger pull equals one bullet. They're functionally similar to many hunting rifles and handguns that nobody's trying to ban. The AR-15, they argue, just looks scary because of its military styling, but mechanically it's not fundamentally different from weapons that have been legal for decades. Third, they lean heavily on the Bruin decision. They argue there's no historical tradition of banning entire categories of firearms that are in common civilian use. Yes, the government has regulated certain weapons throughout history, cannons, explosives, fully automatic weapons, but never weapons this popular among law-abiding citizens for self-defense, sport, and other lawful purposes. They also make a self-defense argument that resonates with millions of Americans. These firearms are ideal for home defense. They're accurate, they're easy to use, they have minimal recoil, and in a crisis situation, they give law-abiding citizens the best chance to protect themselves and their families. Banning them, they argue, leaves people defenseless against criminals who don't follow laws anyway. Now, the defenders of assault weapon bans have their own set of powerful arguments, and they're fighting hard to preserve these laws. First, they point to the devastating statistics about mass shootings. While rifles of all types account for a relatively small percentage of overall gun deaths in America, assault-style weapons have been disproportionately used in high-casualty mass shooting events. Think about the deadliest mass shootings in American history: Las Vegas, Orlando, Sandy Hook, Parkland, Uvalde. The common thread? These weapons. They allow shooters to fire rapidly and reload quickly, maximizing casualties in a short time period. The defenders argue that states have a compelling interest in preventing these tragedies. Second, they challenge the common use argument. Just because something is popular doesn't mean it's constitutionally protected, they argue. They point out that these weapons only became widespread in recent decades due to aggressive marketing and the expiration of the federal assault weapons ban in 2004. Before that ban expired, these weapons were far less common. Popularity alone, they argue, shouldn't determine constitutional rights. Third, they make a historical argument of their own. The Founding Fathers never intended for the Second Amendment to protect access to military-style weapons that can kill dozens of people in seconds. They argued that the Second Amendment was written in an era of muskets, weapons that took 20 to 30 seconds to reload after each shot. The founders couldn't have imagined the firepower available today. They point to historical regulations on dangerous weapons, laws against carrying concealed weapons, prohibitions on certain types of ammunition, restrictions on where firearms could be carried, as evidence that regulation has always been part of the Second Amendment landscape. Finally, they emphasize that these bans don't eliminate the right to self-defense. Citizens can still own handguns, shotguns, and many types of rifles. The bans only target a specific subset of weapons that are particularly dangerous in the wrong hands. Let's bring this down to earth with some real-world examples, because legal theory is one thing, but actual human impact is another. Meet Sarah. She's a 32-year-old mother of two who lives in a state with an assault weapon ban. Before the ban, she legally purchased an AR-15 for home defense and sport shooting. She took safety courses, practices regularly at the range, and keeps her firearms secured in a biometric safe. Under the ban, she's grandfathered in. She can keep her weapon, but she can't buy accessories for it. She can't sell it within her state, and she faces criminal penalties if she fails to comply with registration requirements. Sarah feels like she's being treated like a criminal, even though she's never broken a law in her life. She's following this Supreme Court case closely because it could determine whether her children will have the same rights she had. Now meet David. He survived a mass shooting at a public event where the shooter used an AR-15 style rifle. He watched people around him fall, heard the rapid gunfire, and carries those scars, both physical and psychological, every single day. For David, assault weapon bans aren't abstract legal questions. They're personal. He believes that if these weapons were harder to access, the shooter might not have been able to kill so many people so quickly. He's terrified that this Supreme Court case might make it easier for future shooters to access these weapons. Then there's Officer Martinez, a 15-year police veteran. He's responded to shootings involving various types of firearms. He'll tell you that officers face incredibly difficult situations when suspects have high-capacity semi-automatic rifles. The firepower imbalance can be dramatic, but he'll also tell you that most gun violence he responds to involves handguns, not rifles. His perspective is complicated. He supports the Second Amendment, but he also knows the capabilities of these weapons firsthand. He's watching this case wondering how it will affect his job and his safety. These aren't hypothetical people. These are real perspectives from real Americans who are all affected by this issue in different ways. And here's the thing, they're all being reasonable. They all have legitimate concerns. This is why this issue is so contentious. Let's talk numbers for a second, because data matters. According to FBI statistics, rifles of all types account for roughly 3 to 4% of gun homicides annually. Handguns dominate the statistics, accounting for the vast majority of gun deaths. However, rifles, particularly semi-automatic rifles with high-capacity magazines, have been used in many of the deadliest mass shooting events in American history. States with assault weapon bans have implemented them differently. Some ban specific models by name, others ban weapons with certain features, some grandfather in existing weapons, others require registration or even confiscation. The economic impact is significant too. The firearms industry generates billions in revenue annually, and AR-style rifles are among the most popular firearms sold in America. Here's where we need to zoom out and look at the massive constitutional question at the heart of this case. How do we interpret a 230-year-old document in the context of modern technology and modern threats? This question goes way beyond guns. It's the same question we face with the First Amendment and social media, the Fourth Amendment and digital privacy, the Commerce Clause and internet regulation. The Constitution was written in a completely different world. No internet, no phones, no cars, no electricity. Warfare was conducted with muskets and cannons. Communication traveled at the speed of a horse. The Supreme Court has to decide, do we interpret the Second Amendment based on what the founders specifically envisioned, or do we interpret it based on the principles they established? This is called originalism versus living constitutionalism, and it's one of the fundamental debates in American law. Justice Clarence Thomas, who wrote the Bruin decision, is a strict originalist. He believes the Constitution should be interpreted based on its original public meaning, how people understood it when it was ratified. Under this view, you look at historical practice and tradition to determine the scope of constitutional rights. But here's the challenge. How do you apply 18th century principles to 21st century technology? The founders protected arms, but they lived in a world of single-shot muskets. They couldn't have conceived of weapons that fire 30 rounds in seconds. Does that mean such weapons aren't protected? Or does it mean the principle of armed self-defense extends to modern defensive tools? This same debate plays out with other amendments. The First Amendment protects speech, but the founders didn't know about radio, television, or the internet. Does free speech protect online posts the same way it protects pamphlets? Most people would say yes. The medium changes, but the principle remains. The counterargument is that some technological changes are so significant that they require new considerations. Nuclear weapons are arms, but nobody argues the Second Amendment protects private ownership of nukes. Why? Because some weapons are so destructive that individual ownership threatens public safety beyond what the founders could have imagined or intended. Where do assault weapons fall on this spectrum? That's the billion-dollar question. Are they more like muskets and modern handguns, traditional defensive arms updated for modern times? Or are they more like machine guns and explosives, weapons so dangerous that collective security interests outweigh individual rights? The Supreme Court is going to have to grapple with this question, and their answer will reverberate far beyond gun rights. It will signal how this court approaches constitutional interpretation generally, especially regarding rights and technologies the founders never encountered. Let's get into the crystal ball and talk about what might actually happen when the Supreme Court issues its ruling. Spoiler alert, nobody knows for certain, but we can identify the likely scenarios. If the court rules that assault weapon bans violate the Second Amendment, the impact would be immediate and dramatic. Every state ban would likely fall. California, New York, Connecticut, Massachusetts, Maryland, New Jersey, Hawaii, all of them would have to repeal or significantly modify their laws. Millions of firearms that are currently restricted would become legal for purchase. Gun rights advocates would celebrate this as a massive victory for constitutional rights. Gun manufacturers would see a boom in sales. Second Amendment groups would likely push for even broader interpretations of gun rights, challenging other regulations like magazine capacity limits, permit requirements, and waiting periods. Gun control advocates would be devastated. They'd worry about increased access to these weapons leading to more mass casualty events. Some states might try to find creative workarounds, maybe focusing on licensing requirements, training mandates, or storage laws instead of outright bans. If the court rules that states can ban assault weapons, it would represent a major victory for gun control advocates and a significant limitation on the Bruen decision. It would signal that common use doesn't automatically mean constitutional protection, and that states retain substantial power to regulate firearms in the interest of public safety. This would embolden other states to pass similar bans. We might see a wave of new assault weapon legislation in blue states. Gun rights groups would be furious, arguing that the court had betrayed the Second Amendment. They'd likely shift strategies, focusing on other legal challenges and political battles. The Supreme Court might issue a narrow ruling that doesn't definitively resolve the broader question. Maybe they rule on a specific technicality in the case, or they send it back to lower courts with instructions to apply certain standards. This would be the most frustrating outcome because it wouldn't provide clear guidance, and the legal battles would continue for years. The court might create a framework where some assault weapon regulations are allowed, but others aren't. For example, they might say states can regulate certain features or capacities, but can't ban entire categories of commonly owned weapons. Or they might uphold bans on certain accessories while striking down bans on the firearms themselves. Now, here's what I think is most likely based on the court's current composition. We have a 6-3 conservative majority, most of whom are sympathetic to gun rights. Chief Justice Roberts sometimes votes with the liberals on high-profile cases to avoid extreme outcomes, but on Second Amendment issues, the conservative bloc has been pretty solid. My educated guess, the court will strike down or significantly limit assault weapon bans, but they'll try to leave some room for states to regulate. They'll probably create some kind of framework that protects commonly owned weapons, but allows regulations on particularly dangerous features or accessories. They'll want to avoid a ruling so broad that it invalidates every gun regulation, but they'll also want to honor the Bruen precedent and protect Second Amendment rights. But here's the honest truth. Predicting Supreme Court decisions is notoriously difficult. These justices surprise observers all the time. The oral arguments will give us clues about how they're thinking. The questions they ask, the concerns they raise, the historical examples they reference, all of these will help us gauge where they're leaning. All right, let me bring this home. Why should you care about this case, even if you've never touched a gun in your life and never planned to? First, this is about constitutional interpretation. The principles the court establishes here will affect how we understand all of our constitutional rights. If the court takes an extremely originalist approach, it could limit how other rights are understood and applied in modern contexts. If they take a more flexible approach, it could affect everything from digital privacy to free speech online. Second, this is about federalism, the balance of power between states and the federal government. If the court says states can't ban assault weapons, it's a statement about states' rights to regulate within their borders. If they say states can ban them, it affirms state sovereignty on public safety issues. This balance affects countless policy areas beyond guns. Fourth, the political implications are enormous. Gun rights are a defining issue for millions of voters. This ruling could energize or demoralize voters ahead of future elections. It could shift the political landscape in states where gun rights are a wedge issue. Fifth, this affects the Supreme Court's legitimacy and credibility. The court has faced criticism in recent years over its perceived politicization. How they handle this case, whether they're measured and restrained or bold and sweeping, will impact how Americans view the court's role in our democracy. How the Supreme Court navigates this divide, how they balance these competing values, how they articulate the reasoning behind their decision, all of this matters far beyond the technical legal outcome. It's a test of whether our institutions can handle our deepest disagreements with wisdom, fairness, and respect for all perspectives. So where do we go from here? Well, Supreme Court cases move slowly. The court will hear oral arguments, which will be public and fascinating to watch. Then the justices will deliberate privately, debate among themselves, and eventually issue a decision. This could take months. We might not get a ruling until the very end of the court's term, which typically concludes in late June or early July. During this waiting period, expect intense advocacy from both sides. Gun rights groups will file amicus briefs, friend of the court briefs, arguing their position. Gun control groups will do the same. Legal scholars will write articles, politicians will give speeches, the media will speculate endlessly. And here's the thing, no matter what the court decides, this fight isn't over. If assault weapon bans are struck down, gun control advocates will pursue other strategies, licensing, training requirements, safe storage laws, liability insurance mandates. If the bans are upheld, gun rights advocates will challenge other regulations and push for legislative victories in friendly states. The Supreme Court isn't the final word on gun policy in America. It's one voice in an ongoing conversation that includes voters, legislators, governors, presidents, and yes, young people like many of you watching this video who will shape the future of these debates. So here's my challenge to you. Don't just be a passive observer of this historic moment. Get informed. Read the actual court documents when they're released. They're public records. Watch the oral arguments when they happen. The Supreme Court releases audio and transcripts. Understand both sides of this debate, even the side you disagree with, especially the side you disagree with. Talk to people who think differently than you do. Have conversations, not arguments. Listen more than you speak. Recognize that people on the other side of this issue aren't evil or stupid. They're fellow citizens with different experiences and priorities. Remember, your voice matters. Your vote matters. Your engagement with these issues matters. Don't let anyone convince you otherwise.